Okay. So I'm interviewing Robert Hurt, who's has an incredible history of fighting for legal advocacy issues. And Bob, could you introduce yourself and tell the public this in 1 minute who you are and what you do?
Well, I go by the name Bob Hurt. I was born in Houston, Texas in 1943 and spent 9 years in the Navy and the rest of my life until 2002 in the computer industry. And my most recent involvement there was developing a computer diagnostic test and maintenance products. But since that time, I've gotten out of the commercial world and into the study of law in a disorganized, independent manner.
Well, I can see you're a highly intelligent individual after talking to you for several hours now, and I'm curious, how did you get so emotionally and intellectually attached to finding out more about law and wanting to do your part to help make a better system?
Well, there were really two pivotal issues. The first issue had to do with my interest in income tax. During my entire business life, or at least the most recent 10 years of my active business life, I'd had nothing to do with income tax. My wife at the time hired an accountant to do our corporate taxes and personal taxes, and I simply signed the forms. So I paid no attention to it. But when my wife and I parted and went our separate ways in 1999, I was faced the next year with having to file a tax return. So I made decisions about this, and my first decision was to study it because I never did believe that it was appropriate. It was just less trouble to go ahead and pay up rather than to fight the IRS over it. Well, I changed my mind. One of the reasons I changed my mind is my income had dropped precipitously as a consequence of changing from being an active, chairman of a corporation to being somebody who didn't work at all. And the second issue was that after reading about the income tax in the Constitution, in Supreme Court rulings, and in various writings on the subject by a variety of authors, I concluded that the income tax as it is implemented in the United States violates the Constitution and constitutes a usurpation of authority that the Constitution never granted to Congress. Since that time, there are a lot of other people that I have met, fairly prominent attorneys like Larry B. Kraft and Tommy Cryer, who focus on Internal Revenue Service issues, Mac McPherson, and a number of other people who aren't attorneys but have spent a lot of time studying. And I fairly conclusively proved to my own satisfaction that the implementation of income tax with respect to people's personal finances is typically a crooked deal, that people get coerced into paying taxes they don't owe, and they get convinced by a variety of influences that they owe these taxes anyway. So a lot of people look at it differently from the way I do. Mm-hmm. But essentially I came to the conclusion that it's a gigantic mafia-like scam that is perpetrated on the people, that the Internal Revenue Service are the implementers of it with the full support of the Department of Justice and the courts. In other words,
we could spend a lot of time on that issue, and
I spent a lot of time on that issue. Yeah. But let's go to the next thing.
Right. I mean, but I appreciate the work that you have done on that, and of course when it comes to income tax, you have to be very careful because many have been persecuted, like Wesley Snipes, who thought he could bring forth some of these theories, and then we also know the documentaries of Aaron Russo. Have you seen that his work?
Yeah, I spread it around Florida a few years back.
Yeah.
In the summer of 2006.
But we won't get too much into that because we know how the government likes to go after people who talk about that.
Well, it's not really the purpose of this discussion, but I would say it was pivotal because coming to grips with the issue and getting beyond the, I guess you'd say, the propaganda of it, put me under pressure to start reading the tax code and stop simply believing whatever anybody else told me. And my reading of the tax code and the Constitution, the Supreme Court rulings on the point, convinced me that I was right, that the income tax as implemented is unlawful.
Right.
All right, so in the year 2006, the second pivotal issue, I attended a court hearing for a friend named Jesse Toka, who had spent 2.5 years in jail for the unauthorized practice of law, which basically means to say that we have a legal services monopoly in every single state that is created by the bar with the force of the Supreme Court behind it, so that ordinary citizens, if they want to advise each other, if they want to become proficient in the law and want to advise other people on the subject, prepare court documents for them, do contracts for them and things like that, which they would be perfectly competent to do, they cannot do it lawfully without the approval of the Supreme Court of the state. And that, of course, is utterly crooked. So Jesse Toka had gone to jail because he had been convicted of these misdemeanor crimes of unauthorized practice of law. Well, he asked for a number of people who had been attending meetings in Tampa as part of the Lawman group, which were people interested in Internal Revenue Service issues. And he asked a bunch of the people who attended these meetings to come to his court hearing because he didn't think he would get treated fairly without people there to support him as a show of presence, so the people, the bailiffs and the judge, could see that people were there in support of him and therefore walk a little more lightly than they otherwise might have through his case. So 11 of us showed up in the courtroom, and while I sat there on the 29th of March in 2006 in that courtroom, I watched a senior judge of the Florida 6th Judicial Circuit stomp on Jesse Toka's constitutional rights, and as a matter of fact on the rights of everybody in the courtroom.
A total abusive process of what we were discussing before, that you were bringing forth a number of areas where he was basically unauthorized to conduct the court the way he did. So what were those items?
Well, the first thing the judge did, one of the people who went to attend the hearing was an attorney, and he had brought a video camera and had a press pass with him, and he said that he told the judge he wanted to set the camera up and let it roll and proceed to record the proceeding. The judge asked him if he was part of the mainstream media. He said no, and the judge says, well, no, you can't record it. Well, that right away violated Article 1, Section 24 of the Florida Constitution, which allows access to public hearings and public records. And it also was an abuse of the judge's authority, because even though he has the right to determine where the camera is placed and make sure it's not a disruption, he has to determine whether it is a disruption, and it wasn't. So he, without any cause or reason other than the fact that he was powerful and could make this decision, denied us the access to a recording. Well, this is important. Whenever the integrity of the court is drawn into question, then if you don't have a recording of it, you can't prove what happened in the courtroom, and it's your word against the judges. Who do you think the public is going to believe? So it's important to make a recording of court proceedings. And
transparency is the one of the hallmarks of an honest government, right?
Yeah, right. And without that, it lends itself to dishonesty. So the first thing the judge did is he stopped that. Well, Jesse protested against it, and among other things, he said, look, this is an unfair proceeding. You've already denied this one constitutional right. I think you're throwing me under the bus, and you intend to get me to allow this persecution to go forth and to result in a conviction, and I'm going to get thrown into jail when I didn't do anything wrong. The issue was a probation violation. He had previously sat in and given testimony to the state attorney, Frank Migliore, and Frank Migliore and his associates had used this, he was an assistant state attorney, and he had used this information to dig up other information and use that other information he dug up to get Jesse Toka convicted of this crime of unauthorized practice of law. So if Jesse hadn't cooperated and had been granted, by the way, immunity from prosecution, if he hadn't cooperated in that but by testifying, he never would have gone to jail. So they completely ignored his Fifth Amendment privilege, and they violated it by promising him they wouldn't prosecute him when they actually ended up doing so. So in other words, it was a gigantic deception, and he wasn't going to fall victim to it. He was supposed to give the supervisor of his probation, the Salvation Army, information about his financial affairs. He refused to give it because he thought it would lead to just another conviction, just more persecution. So they considered that a probation violation, and he had done 3 of these instances.
Where is it written that that's a probation violation?
Yeah, well, anyway.
Isn't the judge making this stuff up?
No, it was the prosecutor making it up.
Oh, the prosecutor was making it up, but the judge was going along with it.
We don't know, because it didn't quite get to that point. Before it ever got to the point of judge making a decision about this, it became obvious that the judge was prejudiced because he wouldn't allow recording of the proceedings.
So you asked him to recuse himself?
Jesse did. He asked the judge to stop the proceedings so that he could prepare a legally sufficient motion for the disqualification of the judge for prejudice, because he feared that the judge was going to throw him under the bus, so to speak, and not give him a fair trial.
Okay, stop there. When that oral motion is made, okay, what's the proper actions the judge should be taking?
Well, under the rules of judicial administration in Florida Statute 38.10, the judge must not argue about it, but simply stop the proceeding, give 10 days for the injured party to file a legally sufficient motion with the court, and then if the legal motion is legally sufficient, the judge must disqualify himself if the person, whether it's the defendant or the plaintiff, regardless who the litigator is, he gets to disqualify the judge. There's one free disqualification if you fear that you can't get a fair hearing for some reason or another. And especially if the reason is because of the judge.
Care to name the judge?
Say that again?
Care to name this judge? What's his name?
Judge Seth Walker.
Uh-huh.
He's a senior judge. He's since retired. So the judge was a nice grandfatherly type of guy. I would ordinarily love the man. He seemed like a really precious human being, but he just flat denied this guy's rights, and it's not appropriate. So when somebody that's ignorant of the law but can read the plain language of a constitution does read it and does make an assessment of a situation and says this is a very crystal clear violation of somebody's rights, hey, how much discussion do we need? Do we need to be re-educated, brainwashed into thinking you didn't see what you just saw, that it didn't happen? No, it happened.
So you're there as a court watcher.
Just a court watcher.
And you're beginning to get embroiled with now civil rights issues.
Exactly. My civil rights were violated because I wanted to have a copy of that recorded proceeding, the recording of the proceeding, so that I could show people exactly what happened in that courtroom. And if you can bring something like that to the press instead of hearsay, there wasn't a member of the mainstream media in the courtroom. If I go tell the member of the press this what happened, he wouldn't believe me. He's going to believe the judge. But if I show it to him and have a legal opinion made of it by some other, a proper lawyer or whatever, guess what? it's going to become patently obvious that the judge violated his duties.
Breaking the law, really. I mean, breaking abuse of process, breaking the laws. I mean, you named the statute, so he's breaking laws, right?
Well, here's what it boils down to. We not only have the right of due process, which means there are rules of court, and we have the right to expect that the judge will enforce those rules. So not only do we have to obey them and obey the timing of those rules, or we have obtained due process if we miss a timing date or a point of timing in the rule, or we don't do something right. We have received due process if the judge dismisses our side of the case or rules against us for a procedural error or procedural violation on our part. But if he breaks the rules, where's our remedy? Where's our relief from this? We're depending on him to keep an orderly system going, and he breaks the very rules that he's supposed to enforce. That simply means we've got an oligarchy, that we've got a judge who has assumed himself to be not only the judge, but the jury and the legislation as well. Okay? He's judge, jury, executioner, the whole thing. And it's not appropriate for us to have to tolerate this stuff. It's an abuse of our rights. Article 1, Section 21 of the Florida Constitution gives everybody the right of access to the court and for the redress of injury and to justice without sale, denial, or delay. That's not an exact, precise quote, but it's very close. Without sale, without denial, and without delay. Part of this denial is I have the right to a fair tribunal. And if I don't get a fair tribunal and I say I want to disqualify the judge because he's prejudiced, and I can have good reason to prove that he's prejudiced, then I'm not being given my Article 1, Section 21 right. I cannot exercise this right if the judge won't get off the bench and leave the case.
Okay, we get that point. And
never get to that point, so therefore...
No, we understand this point. And so we need to get back to what happened in the courtroom now.
What happened in the courtroom is Jesse Toka ended up negotiating with the judge and the prosecutor to save face, to give the prosecutor a way to save face instead of just jamming it down his throat through this legal opportunity. And in the end, this negotiation succeeded in letting him not go to jail. But that didn't change the fact that the judge violated his rights. So I began to think, well, didn't this judge, why does he think he doesn't have to obey his loyalty oath? Because every judge has to swear a loyalty oath, at least I thought so. I mean, when I joined the Navy, I had to swear a loyalty oath, an oath to support the Constitution against all enemies, foreign and domestic. Here's a domestic enemy. If he's violating constitutional rights, I swore an oath to protect. And guess what? My oath, I didn't change it just because I got out of the Navy. I'm still bound by it. I'm a registered voter in the state of Florida. I am bound by my oath as a registered voter. The elector's oath, I swore to support the Constitution of the United States and of the state of Florida. So did everybody else who registered to vote. So has every employee in the government or even in his school system. So guess what? There are millions upon millions of people in Florida who've sworn an oath to support the Constitution, and that means, you know, we have this saying in Texas where I grew up, whoever's closest to the snake, grab a stick and hit it. Now, what that means in common sense terms is, it's up to me to go after that judge if I see him abusing people and hurting them and violating their constitutional rights and violating his loyalty oath. So my first duty is to determine, did he swear a loyalty oath?
Of course, the judge's duty and government's duty, all three branches as a matter of fact, is to protect our rights. What happened to that? Because government, we are the sovereigns. We are the sovereigns of our country. And government is limited. It's limited to the Constitution ordains it has power for. But Amendment 10, as we all know, for those things that the government has no authority for, falls back on the sovereigns to have rights, have their civil rights which are natural rights. The government doesn't give you your rights. That these rights are God given, and why is it that in this case the judiciary, the judges, are in fact attacking our civil rights and not protecting our civil rights? What's going on here?
Well, I sought to find this out. I mean, it was crystal clear this judge was a fairly benign judge, but he still stomped on Jesse's rights and my rights too.
Yeah. By the way, did he get it appealed?
And he did it just because he could. No, Jesse didn't go to an appeal. He did go to an appeal ultimately, and he won. But he is free. He got set free. So anyway, here's the point. What happened is
Well, that's a victory, little victory. But go ahead.
Well, that's the end of that issue. Let's just say that's not the issue anymore. Now, this brought up a new issue, and that new issue is this.
Okay.
Did the judge swear a loyalty oath? Did he have an obligation to do some kind of behavior as a consequence of swearing this loyalty oath? And did he violate that obligation? And what's my path to relief and remedy? So these are the four fundamental issues that evolved as a consequence of my going to this proceeding. So that changed my game. It gave me a game to play that I wanted to play. So I began to play it by digging for the judge's loyalty oath, but I hit a bit of a stumbling block when that had to do with my knowledge of the law. I didn't really know what the law said with respect to loyalty oaths, so I decided to dig in and find out. I discovered that in Florida we have 6 separate oaths that a judge has to swear before he can lawfully perform his duties. And then I discovered later that the Supreme Court disagrees with me, the Supreme Court of Florida. And this is what the law says. First of all, a judge has to be a bar member in order to become a judge for a minimum of 5 years before he goes to become a judge, or in the case of the Supreme Court justices, 10 years. Now, and that means I should go look and see, did he have to swear an oath of loyalty to become a member of the bar? And I found out that he surely does. In the Bar Journal, I found a copy of the oath that all bar members have to swear in order to become bar members, and they have to say in that oath, I will support the Constitution of the United States and of the state of Florida. So there's oath number 1. Well, I went to try to get this oath. Who has it is the bar examiner, and the bar examiner refused to give me a copy of it and said the only way anybody could get it was to pay $30 for it, and the only one that could do that is the person who swore the oath. It's their personal property. So, I mean, it's the bar's personal property.
There seems to be a problem there, among other things, that the bar likes to project that they are advocates of transparency, and yet they act in this manner. It just blows me away.
Well, they're totally not advocates of transparency. They hide everything that they feel like. The members of it hide whatever they feel that they need to preserve the bar. Self-preservation is their first instinct. So what happens is the bar and the bar examiner are 2 different entities, but at least they claim they are. And the bar examiner says, we can't help what the bar does, and the bar members itself say, we can't help what the bar examiner does. But the point is, the bar rules require the oath, and the oath says, I'll support the Constitution. And if you want to get a copy of that oath, you have to go to the bar examiner, and the only person you can get it from is the person himself who swore it. So if I wanted to get it, I'd have to go to the judge and say, Judge, you go get your bar oath. It's going to cost you $30. I want a copy of it. Since it's required in order for you to hold office, I want to see it.
Yeah,
to make sure that you fulfill the requirements. Well, I've never pushed a judge that far because I figured, I learned later that there were more important issues at stake. So the second oath is they have to swear an elector's oath, because all judges have to be an elector in the area in which they're serving as a judge. If it's a district court judge, which is an appeals court in Florida, they have to live in the district. And if it's a circuit court judge, he has to live in the circuit. And if he's a county court judge, he has to live in the county. The circuit usually will comprise 1 or more counties. The district will comprise 2 or more circuits. So that's the first point. So who has this elector's oath is the election supervisor. So I'd have to contact the election supervisor and say, please send me a copy of the oath that this judge swore. Now, the third oath they have to swear is they have to swear a candidate's oath. And the candidate's oath says, I swear that I have sworn the candidate's loyalty oath, so that's the fourth oath they have to swear. That's in Florida Statute 105.031 is the candidate's oath. In Florida Statute 876.05 through 10 is the candidate's loyalty oath. So he has to swear those two. Now, who keeps the candidate's oath is the Department of State of the state of Florida, the Division of Elections, the Bureau of Election Records. So I had to contact this guy, call him on the phone, send him an email, and he would send me back a scanned copy of that oath by email. Okay.
Yeah, this is for the oath of this judge.
And those are the candidate's oath and the candidate's loyalty oath.
Right. This is for
a judge.
The judge in Jesse's case.
Yeah.
Okay.
And then and the next oath is to get the public officer's oath, which is prescribed by Article 2 of the Florida Constitution. Mm-hmm. In the public officer's oath, it says, I will support the Constitution and government of the state of Florida of the United States. Well, guess what? It also says I'm qualified to hold the office. Well, if the judge never swore the candidate's oath, he's not qualified to hold the office. So he just basically lied if he swears that oath, but he never swore the candidate's oath. So that's perjury, and it's a serious offense, especially for a public officer, mm-hmm. Most especially for a judge. Mm-hmm. So anyway, that is one issue. The second issue is that the United States Constitution requires all judicial officers, legislators, and executive officers in the state to swear an oath to support the Constitution of the United States. And 4 USC, United States Code 101 and 102, require all legislators and judges and the executive officers in the state to swear this oath to support the Constitution, and to provide evidence of it as by a notarized or other persons authorized to administer oaths, a sworn or signed statement to that effect, as the law requires. So, if a judge doesn't have this, then he's violated United States law, but guess what? You look for a penalty provision for violating 4 USC 101 or 102, and there isn't one. So even though the law requires it, the law doesn't punish anybody who doesn't do it. So therefore, I ask you, if you have a provision in a contract that says you have to do something, but there's no penalty for not doing it, if the contract stipulates there's no penalty, then what's the point in having it in the contract? There may be an equitable reason, but you can't expect the court to enforce it.
If it ever came in, there was.
Here's my point.
Yeah.
It's an equitable issue, and that means you can go to court. You should be able to go to court and say, Judge, the law says the guy should swear his oath, but he didn't do it, and he didn't get it notarized or whatever. And so, Judge, I want you to force him to do it. Now, the judge has the authority to force him to do it because the law requires it, even though there's not a penalty for not doing it.
Well, you still have the problem. He already acted before he did it.
Yeah, but so what? Then we can ask. That's another equity.
Now you're asking for a retroactive remedy.
Yeah, well, let's just follow through on this.
Okay.
The point is that's another equitable remedy. The judge can say not only that, but you issued a judicial order.
Right.
During the time that you had not had proper oaths.
That's my point.
Therefore, your judicial order does not have force or effect.
Null and void.
It never happened. And I'm so ordering it. Well, there's a practical issue here. Public policy would say, you know what, in the interest of the government, the public, and the whole other thing, we're not going to invalidate every order that judge has issued for the last 5 years because he didn't have a loyalty oath on record.
Right.
Okay, so they're just not going to do it. And now you're going to take this to the Supreme Court, guess where you're going to get with it? Nowhere. You're going to waste your time. But nevertheless, you
Well,
could...
that's corruption, isn't it?
No, here's what it is. It is such a monumental expense for government that government will never do it. And not only that, if you take the issue to the newspaper, they won't issue a demand in their editorials. Nobody will write it up in such a way because they'll look like they're vilifying the government. Because guess what? Judges are the daddies and mommies of society. Where we think we don't have a daddy or mommy, we do though, and those are the judges. If they make a mistake, so what? You know, we'll handle it, get it on the flip-flop something. We'll worry about it. It'll all come out in the wash. Who knows? But if it's just the press shines it on and acts like it doesn't matter unless they catch a guy masturbating under the bench or something, then it becomes a big issue. But these other abuses the judges commit are just ignored.
Right. But so there was a. I mean, I know you want to get to the other oaths, but you know, if I may, there was an article finally written about your escapades concerning this issue in the Tampa Bay Tuesday, July 15th.
Yeah, Howard Troxler in the St. Pete Times
and they
wrote about it.
And they write that the paragraph that. Let me see, where is it? 1 second. I had it in my hand.
Well, while you're reading that, let me just point this out.
Yeah.
There's a sixth oath, and that's after being sworn in, the judge has to swear the public employee's oath that every public employee in government and every educational institution in Florida has to swear prior to executing their duties. And under 876.05 through 10 in those Florida statutes, basically says if they didn't swear this oath, they have to get fired by their supervisor. It has to be terminated.
Mm-hmm.
And they can't collect pay unless they did, which imposes an obligation upon the state payroll board to scrutinize their public employees' oaths to make sure they swore them before giving paychecks. But guess what? They don't do it. Now, my investigation uncovered a number of serious flaws, flagrant violations of the whole concept of oaths in the state of Florida. And the first violation was, guess what? David Seth Walker's loyalty oath, he had not sworn one for his current term of office, and he was a senior judge who had gone into retirement and been hired back by the Supreme Court, and they failed to make him swear a more recent public employee's oath. And furthermore, the oath that he swore that was the public officer's oath, he did swear that, but it had no notary signature on it. And guess what? I went to look and found out that the forms for all the election-related forms in Florida's State Department that are downloadable by anybody wanting to be elected, they all had jurats on them before the year 2000.
You better explain to the audience what a
and
jurat
a jurat is the place where either a notary or another officer authorized by law to administer oaths signed it and said, I administered this oath. And so that has to be, that jurat, an executed jurat has to exist, and always did exist on all those election-related documents, and 876.05 requires that jurat on the public employee's oath and the candidate's loyalty oath. So our bottom line here is without a jurat, the thing isn't valid, and it's the same as not having been executed at all. Because in principle, the judge could say, look, honey, to his wife or his mistress, look, honey, I'm busy right now. I'm taking a shower. Hand me a drink, and by the way, sign my loyalty oath for me while you're at it. You know.
Yeah.
So
but the lawyer's reply to you is saying, according to this article, to be sure, the lawyer's reply that Florida's government is still legit, but there's now a pending, but apparently there's a pending federal lawsuit.
Yeah, I'll get to it.
Okay.
All right. So basically, prior to this article being written, is when I investigated these things, and I found out that David Seth Walker, who had been the judge in Jesse Toka's case on this particular day, he had a loyalty oath on record, a public officer's oath, but he didn't have a public employee's oath, nor did he have a candidate's oath. on record. And there was no jurat on his public officer's oath. Well, the Constitution doesn't require it, but as a matter of practice, people put it on there anyway. I mean, the State Department puts it on there way because there's also an attestation that the judge accepts the office, and it's part of the same form. So guess what? It has to be notarized. And it wasn't notarized. So as a consequence of this, I'm looking at it thinking, holy smokes, this is weird. Well, guess what? In the process of doing these discoveries, I dug up oaths on all kinds of people. And I got Jeb Bush's loyalty oath. Well, the first one I got is in the notebook. I don't have a copy of it on hand, but it's in a notebook by a friend of mine he was the first one to show it to me. And Jeb Bush had signed it for his first term where the notary should sign it, and there was no notary jurat on it. The jurat was visible, but it hadn't been executed. So Jeb Bush did not lawfully hold office during his whole first years in the state of Florida. And then I got his second term oath, and that second term oath didn't even have a place for a jurat on the form. Why? Because his Secretary of State, Catherine Harris, or one of her underlings, had ordered the removal of the jurat from all of the election-related forms. When I noticed this, by downloading these forms and looking at them, I went kind of nuclear.
Surely that can be considered a crime.
It's totally evil. So here's the point. I wrote letters to Laura Rush, the chief counsel for the Office of State Courts Administrators, who works for the Supreme Court. She may report to the director of the Office of State Courts Administrators, but she interacts with the Chief Justice all the time. And so she has a direct line to Fred J. Lewis, or Fred Lewis, or whatever, I don't remember his exact name, but Lewis was his last name, and he's still a Supreme Court Justice, but he was the Chief Justice at the time. And I wrote to him, I wrote to her, and I wrote to the attorneys in the State Department, and I complained of this. I said, no, it's bad enough these guys aren't swearing their loyalty oaths, which means they don't validly hold office. But unless I miss my guess, and I don't miss my guess and things like this, nobody in the state of Florida that's been elected any time since the year 2000, and it is now in the deep bowels of 2006 in the summertime, nobody who has been elected during this time or appointed to office validly holds office, because none of them have a loyalty oath with a jurat on it.
Unbelievable. Now, this is just incredible.
They are missing jurated loyalty oaths, is my point. Now, I didn't get to this point of the sixth oath, which is the public employee's oath. Who holds that oath is the personnel department. Well, in the case of the Office of State Courts Administrators, it's hard to know who would have it, because a circuit or a county judge lives over here in the county. They have a state courts administrator, a trial courts administrator in every judicial circuit, and there's the state marshals and all the district courts. So the marshal is the, I guess, office manager who holds on to the loyalty oaths, the public employees oath for all the district judges. This trial courts administrator keeps the loyalty oaths for all of the county and circuit judges. So that means the citizen who wants to find out if the judge is qualified through loyalty oaths has to run all over the place to get these loyalty oaths. And when I personally went to the 6th Judicial Circuit and asked the public information officer, Ron Stewart, to give me copies of 2 judges' oaths whom I suspected didn't have valid oaths, he gave me these oaths at a charge of $15. He charged me $7.50 a piece and wouldn't hand them to me. And because I demanded them there in his office, I didn't raise my voice, but I did demand them loudly enough for other people in the office to hear me, and he refused. I said, well, okay, I want you to send them to me anyway. And I paid them the $15, and they sent them to me, and in the mail. A few days later,
Well, at least you got them.
Yeah, hey, they're not supposed to cost me but 15 cents a page.
Right.
According to the public records
Right.
law under Chapter
least,
119, 15 cents a page.
No, I'm not defending them, but at least they didn't.
Well,
you got them.
Yeah,
so,
that's true, but that's lucky. But there is a reason that I got them, and let me explain why. After I complained to the Supreme Court and to the trial court's administrator and to the State Department, changes were made. First of all, in June or July of 2007. The State Department issued an order, the Bureau, the State Department's Division of Elections manager said, we are now, or he changed all the forms on the election-related forms on the website and posted brand new forms, all with jurats on them.
So that's funny, because if the Supreme Court originally said, we don't think it's a problem. We don't.
No, they didn't originally say anything at this point. Okay, they hadn't said anything about it.
But early in the conversation,
no, they didn't. They hadn't said anything at this point.
Early in our interview, you said at some point.
Yeah, I'll get to that. But what happened is, at this point in time, this was. Remember, I started my research in 2006. Well, in 2007, in June, after me complaining for months on end, the State Department finally got all their forms updated on their website, so they all had spaces for a jurat on them. Hey, great. They realized they'd made a mistake, and they corrected it. So what does that say? That individual activism matters. If there's a snake and he's dangerous, grab a stick and whack it. I did that. That is what this whole interview really should focus on, is that individual, personal, taking responsibility for something that's out of order and pushing on the right people without being hateful, snotty, suing and things like that.
Okay.
Go at them administratively and reason with them and show them the law. Do your homework and be persistent and hammer away, eat away on them. They're going to respond usually in a sensible way, because they, after all, they want to do a good job.
In this case, it was merely injunctive relief.
It could have been injunctive relief, but I didn't have to resort to any of that.
Right. But it was a method of injunctive relief.
Actually, what it was is being polite, notifying people that there was an error and asking them to fix it. And telling them, and without saying that whoever created this error was a complete absolute idiot.
Is this an administrative error?
Huh? Yeah, I wasn't an administrative error.
No, is their doings failing to do the proper procedure for these oaths an administrative error?
It was an administrative error, but it was more than that.
Were all the people involved?
It was a conspiratorial crime that was foisted off by Catherine Harris or one of her underlings, or by Jeb Bush, who probably looked at Catherine and talked to his attorney general and said, hey, isn't there some way to get rid of this jurat? I don't want to have to sign this. This is crazy. I don't want to have to do this. This is a pain in the neck. Everybody in Florida's got to do this. This is crazy. All these officers, let's not do this.
Well, that's
find me a way out.
I'm more interested in...
You need to listen to this.
Yeah.
He says, find me a way out. So he pointed to the code in the statute that deals with courts, where the court says you don't have to sign something you can sign it under penalties of perjury, but you don't have to swear an oath, because the whole court system's got a penalty of perjury thing for your lying. And if you lie to a government officer, it is perjury in the performance of his duty. So therefore, we shouldn't really have to swear an oath. Well, guess what? That was a wrong interpretation of the law, and whoever gave them that interpretation gave them a plausible deniability of responsibility. Catherine Harris probably used that as her justification for get rid of the jurat, and it was crooked. It was completely nonsensical and crooked, even though it gave them alleged plausible deniability. They should have been. The law is crystal clear. Okay,
then that's for the candidacy oaths.
No, that was for the public employee's oath. We haven't got to the candidacy oath. That was also the public the public officer's oath.
Okay.
Now here's what happened.
I can't keep up with it all. There's so many. I'm sorry.
Keep up. You're doing
I'm
okay.
not as bright as you.
Then the next thing that happened is in 2007. in the November or October of 2007, the director of the Office of State Courts Administrator sent a notice, a memorandum, to all of the trial courts administrators and the marshals and in the districts, and said, the Supreme Court Chief Justice has reminded me that all these people need to have valid oaths on file, the public employee's oath. So therefore, I'm strenuously, or something to that effect, recommending that every judge get busy and get your oath sworn again. If you haven't done it, do it, and if you have done it, just make sure you did it.
So Bob Hurt was right.
Exactly. And he did that because of my pushing on Fred Lewis.
Mm-hmm.
So what happened is, in October, somewhere between October and February, most of the judges in Florida went out and swore their oaths all over again, their public employees' oath, and got them all on record.
So say it's too late.
So later, when I went into the 6th Judicial Circuit courts and asked the public information officer if he would give me a copy of those 2 oaths, and he charged me $15 for them, that was after this had happened. And lo and behold, they had actually done this job, because I was checking on them to see, did they follow the orders? Do they have a valid oath on record?
They should pay you. They should pay you.
Well, they should, but they didn't. Now, here's the next thing.
Okay.
Next thing are these questions. Well, if for 6 years, from 2000 to 2006, there wasn't a single official elected or appointed in Florida lawfully, did they lawfully hold office? Did we have a valid government during that period of time? The answer to that is no. Jeb Bush was fraudulently held office, and let me explain this, why that guy was wrong that wrote this newspaper article, or this lawyer for the government. Mm-hmm. Here's the reason he's wrong. Because he was referring to what's called the de facto public officer doctrine. The de facto officer doctrine basically says that if a person who qualified for office holds office and then becomes unqualified for some reason, he's still got his office, cut him some slack. Let's not put the burden upon the society of having to deal with throwing him out, telling him all his official acts are no longer valid, blah, blah, blah. Mm-hmm. Look, we screwed up, made a little mistake. It's not earth-shaking. He did his basic job. He did qualify. Then he did a decent job. Just because for some technicality he didn't qualify, who cares? We're going to continue him in that position, and by the way, we're going to make him go qualify right now. He's going to correct this problem. Mm-hmm. Okay. That's what the de facto officer doctrine is. It says that if you were qualified and you became disqualified, we're going to go ahead and allow your official acts to stand. But the problem here comes into this real point. They never qualified to begin with if they didn't swear one of the oaths that's necessary to qualify for election or appointment. That means the candidate's loyalty oath. It happens to be the candidate's loyalty oath and the public officer's oath are worded the same. Mm-hmm. So they have to tweak the wording to comply with the law a little bit. Mm-hmm. But guess what? They still have to swear it. In order to become a judge, you're not a part of the judicial branch of government until you qualify. Mm-hmm. And in order to qualify, the Constitution stipulates the qualifications and the law stipulates another one. You've got to sign this loyalty oath. And if they didn't do it, and none of them did,
they're just...
Well, I won't say none of them, but if they didn't have jurats on them, they never qualified. Mm-hmm. So they lied and committed perjury when they swore their public officer's oath. Mm. That's in there. It's required by the Constitution, the constitutional law.
That includes all 3 branches.
Everybody that swore it that didn't have a candidate's oath on record,
public officer.
Validly notarized candidate's oath. Okay. Exactly. So my point was, I presented this to the Supreme Court and to the State Department. I said, look, we've got a situation where we don't have a government. Mm-hmm. What we have is a government of people that have not done their job as far as qualifying concerned. I don't think they're a bunch of evil, low life, no count folks. I just think they screwed up, and they screwed up because the wrong oaths were on the
Heads should roll.
What'd you say?
Heads should roll. And let me finish my statement. They were acting in their administrative capacity, and when even a judge acting in his administrative capacity is liable to be sued.
Yeah, of course, he doesn't have immunity for that, either administrative or ministerial duties.
Right.
If
and that's what happened here, isn't it?
Yeah, but
these
guess what?
judges could be sued.
Yeah, that's right, but I didn't sue him, and I didn't think it was appropriate to sue him because they corrected their problem. To a point, but guess what? Unfortunately, even to this day, nobody has corrected the problem that appointed judges don't swear candidates' oath, though they should. Here's what happens in Florida. When you want a Supreme Court judge, the governor appoints a Supreme Court justice, but he has to get elected to stay in office for succeeding terms. And whenever a vacancy occurs in any judgeship around the state, either circuit court, district court, or whatever, the governor will appoint a new judge. And there are judicial nominating commissions to select lawyers and various other people who qualify for judgeships and to propose them to the governor. Well, guess what? They should get those candidates to swear the candidate's oath, and none of them do. They never do. And guess what? They're ready and primed for a lawsuit because I have put them on notice repeatedly.
Okay, and what about this federal case?
Well, the federal case dealt with...
who's having the federal case?
There's a man down called John Thompson, John B. Thompson.
Yeah, okay.
Jack Thompson.
Jack.
He was an attorney who basically the bar wanted him out because he was a pain in the butt, and the reason he was is because he went after, on a religious basis, presumably, Howard Stern for his prurient content, 2 Live Crew, and the makers of these horrible games,
right.
Grand Theft Auto or whatever, are selling these things to kids and airing content that children shouldn't listen to. So he was going after him, and he won huge damage awards and got Howard Stern fined and thrown off of Clear Channel and so forth. So as a consequence, the bar, these guys, these wealthy guys, 2 Live Crew, they hired badass attorneys, Greenberg, Trowrig, and Blank Rome, to come in and do their dirty work. And these guys are all connected throughout. They're like a mafia. And they got this crooked judge who had a fraudulent loyalty oath on record, which Jack Thompson proved with a handwriting analysis. He proved that this judge did not sign her oath, and she testified, no, I never signed my oath, somebody else did, and it was an employee.
I can't believe that.
I'm not joking.
No, you got to be joking.
And the author, it had a signature on it, but she hadn't been the one that signed it. Some employee, some guy from a, who had originated.
Totally illegal. That's for.
Anyway, I don't want to go into too much detail about that, but what happened is Jack Thompson sued him, and he took these issues that I'd brought up, and he hammered the courts with him. And not only that, so did Montgomery Sibley, another Florida attorney, who had to leave and go to Washington D.C. and work as an attorney there because they disbarred him here, and it had to do with his personal relationship, the management of his personal life somehow. But here's the point: he brought up all of these points except for the candidate's oath in his arguments to the Supreme Court, and they issued a ruling in 2008, in September of 2008, that said, we deem that by swearing the public officer's oath, the judge has complied with the statutes, which, of course, is a complete lie. And because he'd brought up the fact that these judges in his case who had disbarred him weren't qualified to disbar him.
Clearly it's not enough. They have to comply with the Constitution.
These people are primed for a lawsuit now.
Yeah.
But see, the people that
But the Supreme Court is clearly wrong in the state of Florida, right?
Yeah, well...
I mean, they have to comply with the Constitution.
Exactly, they do. And they didn't.
The Supreme Court of Florida doesn't give a damn for the Constitution.
That's not true. Okay, let me tell you the truth about it. The Supreme Court people tried to do a good job. Every judge tries to do a job. Most judges, even though they may do a dishonest thing, are by and large honest judges who try to do a good job. They're under a lot of pressure, and they're eminently, and most of them are very well qualified for their work, and they know a lot about the law, if not.
Yeah, but their actions speak.
That's not the point. Just calm down for a second.
Yeah.
What happened with the Supreme Court is they looked at the economy of everything, and they concluded, if we let this case go forward and have this thing brought up, it's going to do untold economic and PR damage to the government. because the economic damage is going to come as a consequence of having every conviction for every crime by every judge in every court in the state of Florida for the last 6 years is going to be thrown out. That cannot happen. We can't turn this whole thing upside down like that. We cannot let this happen.
So you open a can of
And they
worms.
found a way they found a plausible deniability type of escape hatch to say, we deem that the legislature does not have the authority to impose obligations beyond those the Constitution imposes for qualification for judicial branch office.
Right.
Because we are a separate branch of government. They don't have the right to horse us around and boss us around. They can't make up laws that make it more difficult for somebody to become a judge than what the Constitution stipulates, and they are right.
I thought the legislature makes
If we are going to put a requirement like this upon judges, we have to do it through the Constitution, not through legislation.
Okay, we'll let the audience decide, but...
no, the audience can't decide it. The Supreme Court already decided it. It's not the audience's business. Screw the audience. They don't know beans about this because they haven't studied the issue.
I don't think that's fair.
Now, wait. Okay, I don't say this to be abusive. I say it to make a point.
Right.
The law means only what the court says it means. It doesn't mean what you and I wish it meant.
Judges have to follow the law.
They do, but guess what? They get a certain latitude in making their judgments, and they often decide what's good for the family. And that may not be what individuals like, but it's in the end the best decision. So even though I don't agree with the Supreme Court...
They messed up and it's damage control. But anyway, I'd like to spend the last 4 minutes on Nancy Grant and getting back to the issue of Jesse Toka's particular issue. What do you think about,
Nancy
Grant and her, the way she was thrown in jail for helping inmates with law research, and she was accused of practicing law.
She didn't help them with law research. What she did was she took to them a pre-written motion for emergency release because of violation of their speedy trial rights, and asked them if they wanted to sign it, and helped them to file it. She went and filed it for them, and they accused her, and also she set up a corporation, I can't remember the name of it right now, but it was something about some kind of the Pro Se Bar. She set up this company called Pro Se Bar, and her purpose was to help people who were being cheated out of justice by the Florida courts and by the Florida prosecutors, the state attorneys.
Was she a victim, or was she practicing law?
Yeah, she's a victim. She did nothing but good. She was a good and an honorable woman. She's a victim of judicial malfeasance and of a good old boys network collusion and conspiracy to suppress her. First of all, that the whole idea that people have to be lawyers or have a license to practice law is absurd. The practice of law should mean being an attorney and saying, I've been to law school, I've studied a lot about this stuff, and I know what I'm doing. That's one thing. But if I go to the great pains to study the law as I have, even though I don't know as much as some attorneys about some subjects, I know a lot more than other attorneys do about certain other subjects. So therefore, that are legal related issues. So therefore, why can't I function as a law professional for money?
Well,
why shouldn't I sell my abilities?
We won't be able to solve that today, but I just want to bring up that issue and that happened. There's 3 minutes left. I want to talk about this bill that's in legislature right now, SB 1524.
I love it. It's fabulous. This whole thing says, hey, we're going to get rid of judicial immunity for tortious conduct by judges. I love this. That's its main point, and it also requires the court to educate the judges, to make the judges become educated in these whole principles, and then enforces to make sure, with oversight, that they actually do get their education and start behaving. The problem is that judges abuse people, such as in the Jesse Toka case, and in the Nancy Grant case. They get away with virtual murder. They destroy people's lives for what? For the good old boys network. And that's the nicest summary I can make of it. We need to stop this dead in its tracks.
Okay, and what about the 5 citizens they want to appoint to some of these committees?
That's fabulous. The putting them on the Judicial Qualifications Commission, adding more citizens, reduces or dilutes the power of the Good Old Boys Network, which is judges and lawyers and governmental buddies of the governor who now populate the Judicial Qualification Commission.
Oh.
Right now, there's no way to get the JQC to really get rid of bad judges.
So you're telling the Florida citizens look into the camera and say support what?
Support Senate Bill 1524 with all your power.
And help that brave senator pass that.
Yeah, let's get that bill passed.
Okay, you got 2 minutes to say anything you want.
Well, I've appreciated the opportunity to tell about the loyalty. Here's the point. Go to bobhurt.com and download the Loyalty Oaths in Florida document, which I wrote for your benefit, and also use bobhurt, BOBHURT.com to subscribe to the Lawmen mailing list. I'm the only person who posts to it. I've posted upwards of 5,000 messages in the last 6 years to it. I think that you'll like it. If you like the law and want to learn more about it, this is a way to do it, and it's free.
And how many members you have?
1,574.
Okay, and thank you so much, Bob, for your time. This has been a pleasure. And keep on fighting, all right?
Yeah, man, thanks.
All right, bye-bye.